This is the fifth in a series of 7 public hearings of the Ad Hoc Committee to Review the Criminal Justice Act. My name is Kathleen Cardone. I'm a United States District Judge for the Western District of Texas. I am chair of this committee. Before we get started, I'd like to introduce the other members of the committee that are here with me today. I'm going to start with those that are on our first panel. Judge John Gerard, he's a United States District Judge from Nebraska. Mr. Chip Frensley, National CJA Panel Attorney District Representative. Catherine Rowe, Federal Public Defender for the District of Minnesota. And Dr. Robert Rucker, Assistant Circuit Executive for the Ninth Circuit. Also present from the committee are members who will be participating throughout these 2 days of hearings. They include Judge Reggie Walton, United States District Judge in Washington, D.C., Judge Mitchell Goldberg, United States District Judge, Eastern District of Pennsylvania, Judge Dale Fisher, United States District Judge from the Central District of California, and note she will be acting as chair for our hearing tomorrow. Reuben Kahn, Executive Director, Federal Defenders of San Diego, and Professor John Gold, our reporter from American University. Not with us today, but always with us in spirit, are Judge Edward Prado, Chair Emeritus of the committee and Judge on the Fifth Circuit Court of Appeals, Neil McBride, an attorney with Davis, Polk, and Wardwell, and Professor Orrin Carr, from the George Washington University. Also, let me introduce staff of the committee, who will include Ms. Erin Brenner, our attorney advisor, Ms. Autumn Dickman, project manager, and Mr. Mark Gable, who is our training specialist. The committee is pleased to be conducting this meeting in San Francisco. In planning all of our hearings throughout the country, it was our desire to have the opportunity to hear from all of our diverse judicial districts by setting up regional locations that would allow us to address all matters before the committee. In particular, at this fifth hearing, the committee wishes to have a particular focus on case budgeting and mega case issues. Now, a brief history of the Criminal Justice Act. The Sixth Amendment guarantees to the accused the right to counsel in serious criminal prosecutions. To ensure that representation, it is now well established that, after assessing the financial condition of the accused, the government may bear some or all of the cost of the representation of the person. The responsibility for appointing counsel in federal criminal proceedings for those unable to bear the cost has historically rested with the federal judiciary. In 1964, the Criminal Justice Act, or what we call the CJA, was enacted. It established a comprehensive system for appointing and compensating lawyers to represent defendants financially unable to retain counsel in federal proceedings. It also authorized reimbursement of reasonable out-of-pocket expenses and payment of expert and investigative services necessary for an adequate defense. Amendments to the CJA in 1970 authorized districts to establish federal defender organizations as counterparts to federal prosecutors in those districts where at least 200 persons annually require appointment of counsel. It is now more than 50 years since the CJA was enacted. There are approximately 81 authorized federal defender organizations who employ lawyers, investigators, paralegals, and support personnel. They serve over 90 of our 94 judicial districts. Those federal defender organizations, in combination with more than 10,000 private panel attorneys, represent the vast majority of individuals who are prosecuted in our federal courts. In April of 2015, I and my fellow committee members had the distinct privilege of being appointed by John Roberts, Chief Justice of the United States Supreme Court, to serve on this ad hoc committee to review the Criminal Justice Act. In doing so, Chief Justice Roberts listed 14 specific issues for us to review. They include areas of judicial involvement in the CJA process, employment and compensation under the CJA, quality of representation under the CJA, and the CJA structure and effectiveness. This is not the first of a kind study. Judicial Conference policy has long supported a periodic, comprehensive, and impartial review of the program. In 1967, the Judicial Conference and the Department of Justice gave Professor Dallin Oaks the sole responsibility of performing such an analysis. Then in 1993, a report authored by the Committee to Review the Criminal Justice Act, which was chaired by our Chair Emeritus, Judge Edward Prado, was presented to the Judicial Conference. It was a 212-page report, and it described the historical evolution of appointed counsel in the federal courts, as well as presented detailed findings. It made 28 specific recommendations to improve the CJA program, to include selection, training, evaluation, and compensation of panel attorneys, the establishment and management of federal defender organizations, CJA funding, improvements to the administrative structure. Many of the Prado Review Committee's proposals were endorsed by the Judicial Conference. It has now been over 20 years since that report. This committee is very thankful for all of the work that was done by our predecessors. In particular, we wish to recognize Judge Prado. His previous effort and the efforts of his committee have been an invaluable source of help in framing the work of this committee. I want to address for all of you just a little bit about the framework of our study. The study is expected to be completed in the spring of 2017, when it will be presented to the Judicial Conference of the United States Courts. Between now and then, this committee, with all of its collective experience and the views of all of its members, intends to gather information, examine the CJA program, debate the issues, and after thoughtful consideration, make its recommendation to policymakers. These findings and recommendations will be well documented and explained in a written report, and the report will be prepared by none other than reporter Professor John Gould. It is the committee's hope that in today's world of computers, email, websites, we're able to sufficiently reach out to the stakeholders and give them the opportunity to provide us with ample information to document our study. For those of you who are not aware, the CJA committee has set up a website at cjastudy.fd.org, which allows anyone to inform themselves about the study and to submit comment to the committee. The committee will be conducting a series of 7 public hearings. The 7 public hearings is in an effort by the committee to hear from a broad spectrum of individuals and organizations and to engage all of them in discussion of the issues. The 7 public hearings have been scheduled as follows. Our first completed hearing was November 16th and 17th in Santa Fe, New Mexico. Our second completed hearing was on January 11th and 12th in Miami, Florida. Our third completing hearing held in Portland, Oregon on February 3rd and 4th. Our fourth completed hearing on February 18th and 19th in Birmingham, Alabama. We're here currently, March 2nd and 3rd, being held here in this lovely city of San Francisco, which, by the way, I don't know who ordered the weather, but it's been perfect so far. Then April 11th and 12th will be in Philadelphia, Pennsylvania, and then finally May 16th and 17th we will be in Minneapolis, Minnesota. We're hopeful that the criminal justice community will come forward to present their views. All of these hearings are being transcribed for the public record. The video and the transcripts from our hearings are now currently posted on our website, and all future hearings will be done the same. Today's hearing is being broadcast live through our CJA Study website, and again, that's cjastudy.fd.org. Before we get started, let me explain a little bit about the format. We are first going to hear from Chief Judge Moskowitz, and then we'll start with the panel.